Started. There we go. Thank you.
Yeah, I want to make sure that it's recorded not only as just a public meeting, but also as a training opportunity for anyone else who want to come back and reference this. So I will be throwing a bunch of information out over the next hour and a half. So it might be helpful to be able to come back to it. So as I was saying before, one of the big changes with the pandemic was that we had to shift to virtual hearings. We have hearings on a consistent basis with the department for a number of different areas of subject matter. And generally we've done it in person. If you have exhibits, you take a piece of paper and you hand it over to the hearing officer. People have to come and be sworn in. You know, there's been this routine process. Now we're in a whole new world with how we're handling these. And so I thought it was important to actually set forth the script of how the flow of these meetings will be presented. Some of the things we want to remind folks in advance of the hearings, things that we never had to say before, like please don't drive during the hearing and while providing testimony. You know, fun anecdotes. So today I hope to run through the process and procedure we set in place, the hearing script that we have set up, which is typically presented by the board chair. If the board chair does not want to present it, then I would hope that today you can decide if there's going to be someone who would run the hearing in lieu of the board chair. But Terry Jo is not on here today. That was actually my fault. I should have brought her or invited her to join us. Terry Jo is another staff person with the department who will be on the hearing that day. So Terry Jo facilitates our board hearing. So she will, when Kat wants to present an exhibit, she will say, Terry Jo, I'd like to enter, exhibit A or DCP exhibit A. Will you please bring that exhibit up on the screen? So she's helping do a lot of that technical flow work during the hearing so that, Kat can really focus on presenting her case. Terry Jo will also gather all of the exhibits from the respondent in a case, and usually a day or two before the hearing, she will be sending things out. She'll be sending out the exhibits to you. She'll also send out the complaint to you. So she's really the hearing coordinator on behalf of the department. So Terry Jo Powell, when you start seeing emails come in, then that's who she is. So one thing you'll notice while we're going through all of this today is that typically all of our hearings are done on Teams. So for Board of Accountancy, we will be presenting on Zoom, but when you see Teams throughout all of these materials, I just didn't go back to change that for this presentation today, but just know the same thing applies just on Zoom. And so I think I'll dive right into it because all the other points are will be touched upon throughout. So what I'm going to do is start off.
Julianne?
Yes.
Excuse me, do you want me to make you the host so you can share your screen and present whatever? Would that be easier for you to do?
I think.
Oh, okay, you started. Okay, you're good. Okay, there you go. Yep.
All right. So just starting off, in general, I know it's been a while since Board of Accountancy had a formal hearing. The hearings are governed in terms of procedure by the Uniform Administrative Procedures Act. And so it is similar to a case in court. However, there is a lower level of burden of proof, as well as a looser standard for what evidence can be presented at the hearing. One thing we've said is that we have to be a little bit more flexible sometimes with the administrative hearings that we've done online, because we find sometimes that a respondent's computer will just drop connection halfway through, that God forbid Kat loses audio connection halfway through, and then we have to make modifications. You might have to adjourn the hearing and then do a continuance for another day. Hopefully that doesn't happen to anyone here, but it's just a reality that's unfortunately happens in this platform that doesn't happen in person. And that's really point 1 and 2, is that if one of these things happens, we roll with it. We'll adapt, and yet you just have to specify on the record what's happened, and that we'll reconvene at another time. So one of the most interesting things, or one of the, I guess, the most drastic changes is how we handle exhibits in this, new online platform, because you can't, as the board members, as the people who are hearing these cases, you can't read any of the exhibits before the hearing. However, we clearly need to get them to you, which means we have to email them to you in advance. And especially if, I'm not sure which date this hearing is scheduled for, but let's say it's scheduled for a Monday, then Terry Jo is going to send it to you, on Thursday or Friday. So technically they will be in your possession, in your email box for a few days in advance. However, no exhibits are in any way valid until they are entered into the record at a hearing. So let's say Kat has 10 exhibits that she puts together for DCP, and DCP exhibit 1 through 10. At the hearing, she may decide she's only going to enter 1 through 6. Maybe 7 through 10 just don't wind up being applicable because they were already admitted to on the record. Maybe she realizes that, she has, like, the respondent gave even better evidence of her case. Whatever it is, in the event she only enters, and that's where she will present to you exhibits 1 through 6 during the hearing, they don't exist and they can't be considered. We are asking, and I will share another document with you guys of what the instructions are that we're giving to respondents and to any witnesses. But we are asking that all documents be provided to us, all witness lists and exhibits are provided in advance so that we can make sure that we have them, that they open properly. So that also that Terry Jo will give them to you so that when it's during the hearing, even though she will present them on the screen, and so she'll be able to share those with you, you'll be able to see them. We also understand that sometimes you want to be able to, if it's a 5-page document, Terry Jo's focusing on page 2, because that's what Kat's saying, I really want to focus on this paragraph. You may want to scroll down and see what's on page 4. You may want to see the entire document and consider it in context. So we will make sure that you have all of those documents. So like for me, I have 2 screens. It's helpful when I'm doing something like this. Or just if you don't feel like you can make a decision on the record, you can go back and review them afterward. Again, you have them all in your possession. So sure.
Well, I have a question. It says 3G exhibits must not be reviewed or considered in advance of the hearing. So
Yes.
We're not supposed to look through them ahead of time?
No, so when Terry Jo emails you these exhibits a few days in advance of the hearing, do not open them. Now, so the caveat there is that I do have people that will say, and through all the boards, that they'll say, I hate reading things on screen, but this document's 20 pages long. Like, how am I going to do this? It is an honor system. So I understand that there are some people, and honestly, I'm one of them, that likes reading things on paper. If you want to click print and just print them out so you have all of the exhibits with you during the time of the hearing, that's fine. Don't read them. You do not review them, print them out and put them in a pile face down. And then at the time of the hearing, then you can review them. But yes, you're not supposed to, because like I said, if Kat doesn't enter and like actually say, I want to enter exhibit 1 onto the record during the hearing, then it doesn't exist. It doesn't matter that she emailed it to you in advance. So yeah, so we're asking everyone to get those documents to us before the hearing. We ask people to get them to us at least 1 week in advance of the hearing. Now, that doesn't always happen. Sometimes people will show up at the hearing and say, but I have this key piece of evidence. I had, another attorney or I had an attorney say that, the way that I interpreted the statute related to accountancy work was valid, and therefore, I acted on in reliance of that advice. And we say, okay, but we don't have that document in the record. People can still enter documents in at the time of the hearing, or the record can be left open to allow people to present in evidence afterwards. Obviously, most convenient if you have it in advance. Things move a lot faster. But during the hearing itself, and Terry Jo's experience with this, which is just awesome. She's been doing this for a while now with different boards. What will happen is that that person can email the document like while you're live during the hearing. They can email it to Terry Jo. Terry Jo will distribute it to everyone. And so you can actually do it, and she will take the document, she'll put it up on the screen so that you can all review it together. And if that can't happen, then you can say, all right, well, you have 2 days to enter or to send us the exhibit and deal with it that way. And then you can consider it afterward. But one of the big things we want to do is that with all hearings, it's important to have a beginning, middle, and end. So we have in here that just if you're going to say you can submit it after the hearing, please specify when. Like you have to get it to us in 2 days, or you have to get it to us in 30 days, whatever is appropriate based on, we have people thinking like in our electrical world, we had someone where they had to get some documents certified by a town planner. That doesn't always happen quickly. So we acknowledge the fact that they may actually need 30 days to get a piece of paper from a human at a small town. So yeah, it's whatever is really practical for the board. So when the documents are, and this is just in person or remote, if there is an objection to the document, so let's say Kat objects on relevancy or Kat objects on authenticity of a document, then, or the respondent does, either way, I'm gonna pick on Kat because she's here. So, if she makes an objection, then the board does need to rule as to whether or not a document can be entered into the record. So that is something that just has to be factored in when, and we'll get to later on in the presentation, what happens if there's an objection and the document's being submitted in after the hearing, not during the hearing, but you've allowed for a few days later. And so, we've talked about this, that they're not considered entered until actually at the hearing. So one of the things that we do ask board members to do is just to kind of keep folks engaged, please keep your cameras on if at all possible. We realize people have tech problems, but if possible, keep your cameras on. And so then the script is usually read by the board chair. Is that how you guys planned on setting it up? If there's any discussion on that. We can also kind of touch on that at the end of the meeting today, but it's just, we need to kind of address who will be handling that in terms of just managing the hearing. You'll notice that there are going to be parts, I'll just highlight them as we go through, but there are parts that are highlighted in gray, not to be spoken, just as notes for the hearing officer. So we'll go down to the script now. So this is really just your opening. Who you're here to hear the case against, who you are, when this is happening, having board members identify themselves so they just know, people know who they're speaking with. You guys all have your names labeled on here, so that makes it a lot easier. If anyone is calling in from a phone number, that's usually, something that's good to just have on there. But it's important in the event that it's important to say your name, because if we have to get a transcript, if the case gets appealed, that's where they're going to want to know, who's actually there, and they can't see the names on Zoom. So the information from this, so I said you can't look at the exhibits in advance. That is true. The complaint is going to be sent to you probably correct me if I'm wrong, but probably in the next week or so through Terry Jo. And the complaint you certainly can look at in advance. That's where all of this information is going to come from. Marcia?
I think we already got that.
Great. Okay. Kat's extremely efficient. So, so then in that complaint, this is where you're going to get this information. So again, who the case is against and what the allegations are related to the general statutes and the regulations. I'm going to send this document to you guys in Word and in PDF. I send it in Word because sometimes it's helpful to just take the information from the complaint and cut it and paste it in here so that you'll just know what the sections are. This is, again, a template for every single board. So, you know, there might be, there are certain things that is helpful to have to fill in the Mad Lib before the day of the hearing. In the event that there's a recusal, then you just note it on the record. If there's no recusal, you skip over the gray. And then let people know, again, this is Zoom, not Teams, but acknowledging that it is a remote hearing. And then this is really the bulk of this is telling people why you're here. So, you know, you're saying the burden of proof is the preponderance of the evidence, and explaining that that just means more likely than not that the respondent violated the laws alleged by the department. The department still has the burden of proof, though, to be able to establish that case. Letting people know that we do use the Uniform Administrative Procedures Act, and understanding that there's, you know, especially if there's another attorney involved, just kind of reiterating that the rules of evidence in court don't necessarily apply for the UAPA. Especially for people who are not represented by an attorney, but really for anyone. What we want to do here too is set up how the flow is going to go. It is, I think for some reason, and I can't really articulate why, it's easier to kind of control a room and have pauses in conversation when you're in person and have like a minute to shuffle papers than when you are on a screen, you know, 12 inches away from a camera. The awkward pauses get a whole lot more awkward. So explaining to people kind of how this flow will work has been beneficial. So the department will start first. So after this is all read, the department will present their opening statement. They have one. Then it will go to the respondent for their opening statement. And then then the parties will start calling witnesses and present their case. So this is just kind of explanation of how that will flow. And explaining that once you have your witnesses, you can cross-examine, and then explaining how the documents must be submitted into the record. Because oftentimes what we'll find is that people will have either, when I say people, the respondent will have emailed in their evidence and emailed in their exhibits. And they're like, so I'm done, it's there. You guys have it, I've entered it in. And it's important to point out to them saying, just because you emailed it in doesn't mean it's on the record. You have to actually say, I am entering this document in. I want this to be considered as evidence. So we also put in, if someone's not represented by an attorney, we always like to give them this extra, you know, prompt of, please feel free to ask questions at any time. It can be a daunting experience for someone who's never had a case brought against them. They've never had to present in front of a panel, never had to present in front of a hearing officer. So just opening that up. And then these are our kind of general instructions. Be clearly, don't interrupt. Keep your video on, don't drive. Keep your video or microphone on mute. And actually something good to note is that Terry Jo is very good about, in the event that Kat's presenting a case and she's speaking with one of the witnesses in the case, and the respondent doesn't have themselves on mute, their dog starts barking in the background, Terry Jo will mute the person. So we do say in here that if, so it's actually right here. So if you leave your microphone on when someone else is speaking, we may mute. So just putting someone on warning there that that happens. And then one of the things too is that, you know, in the past, when we recorded these hearings, generally no one was going on and like listening to these hearings afterwards. We would have it on a tape recorder, digital although it might be, but like have it on tape recorder is in the office. We kept it like in a file in our share drive, and that's it. And unless there was an appeal, no one really heard it. This is now recorded, and there is a link available to the hearing that's accessible through the Secretary of State's website. It is, you know, something that can be very readily accessible to anyone in the industry. Now, we aren't like publicizing these hearing recordings. But what we find sometimes is that people may say, well, you know, and it's usually date of birth is the most common thing that they'd want to disclose for whatever reason. But you know, if you hear someone going down a track where they think they're going to disclose their social security number for some reason or some other, you know, confidential information, I would just say, you know, if we can, we're going to stop that, because it's just not something you really want out there in the world. One of the other things is that the general public, so this is posted as a public meeting, the hearings are posted as public meetings, but people can't come and just give general commentary. So if, like the exhibits, they're also supposed to send us in the witness list a week in advance. Doesn't always happen. So the respondent gets there and says, well, no, I really need so-and-so to testify. Terry Jo, they can do that. Terry Jo can admit the person in to be able to be elevated to the level of presenter during the hearing, but it would be something that either has to be called upon by the respondent or the respondent's attorney. People generally logging in can't participate in the hearing. And then we just have, you know, if anyone has technology issues, then we give them a way of calling in to be able to, oh, actually, I'm gonna have to amend this because this is not your conference ID because you guys are doing it through Zoom. But the number and the email address will still work, but I guess the conference ID will be different. So again, one of the things we have to do for the record in the event that there is an appeal, make sure that we're confirming the participants. So you're just going to go through and ask, we start with the respondent and ask them to say, you know, who they are, spell out their name, and then also state their mailing address, just so you can confirm who they are. Same thing for respondent's counsel, and then any witnesses. Then you move to the department. So you have Kat would introduce herself and then list out the witnesses. Now, we're gonna, I guess this is as good a place as any to do it. So now, Board of Accountancy is interesting. So this is the one board where we have that up to this point, and you know, I don't know if this has been brought up at past meetings, but we're trying to develop some additional support from our investigations division, be able to have an investigator working on Board of Accountancy cases. But to date, our legal division has both served in the role of investigator and prosecutor. This is, you know, just not our normal setup, but just due to resources when Board of Accountancy was transferred over from Secretary of State, we worked with what we had. And so Kat, in this hearing, will be switching roles. So she will be prosecuting the case on behalf of the department, but there will be a moment when she will switch over and present as the investigator. So typically, and what I'm about to say over here is that you're going to swear in the parties, but you don't swear in the attorneys because the attorneys don't provide. So if the respondent is represented by counsel, you don't swear them in because they're not providing testimony. That in this one case doesn't apply to Kat, because Kat will actually switch roles at some point during the hearing and will be answering questions, kind of almost asking herself questions and answering them as the investigator for the case. So it is a unique position. It's not unprecedented in the state. It happens in other agencies where there's just, you know, they're resource strapped. Like I said, it is something we're working on for the future to be able to have a separate investigations team. But for now, there is that one wonky moment. So you will be swearing in Kat as well as any witnesses who will be testifying. Now, depending on how you want to do it, typically what boards have done, but you know, you may handle it differently, is that typically boards will read the oath and, you know, say, I do solemnly swear. Now, will you please affirm the oath? And then say, ask people, so they'll go, Stephanie, do you affirm? And she'll say yes. Kat, do you affirm? She'll say yes. there are other boards that want to read out the oath to every single person and then have them, so that they're reading that statement over and over. I don't really care. As long as you're swearing people in, like, you need to read the statement and they need to verbally agree and affirm that they understand. But again, if you want to read it over and over, then that is absolutely fine with us. So if the respondent does not appear, then you have to confirm that on the record. So if they're not here, the key thing is that Kat then needs to prove that she gave the respondent proper notice of the hearing, so that he had due process. I don't know, so the respondent had due process, and that they had the opportunity to show up and advocate for themselves. So that should be the first step if no one's present. Now, if someone is present for the respondent, then you basically open up the hearing. So opening statements is first. It's very short, and Kat will pave the way for how that goes forward. It is just a few sentences about why we're here, what she hopes to prove. So this person represented themselves as a CPA, however, hasn't been licensed since 1993, or is just a tax preparer, or whatever it is, or somehow like mismanaged client funds, whatever the case is, but it's not providing you evidence at this point. It's just, here's the umbrella of why we're here today. So then the respondent can do the same thing. And just so you also know, you guys are in control of this hearing. So although you may say, please make your opening statement, and Kat gives a 1-minute oration about why we're here, and then the respondent starts, and you're 5 minutes in, and you realize they're just teeing up, because one of the things that happens, especially when someone is not represented by counsel, you want to do that. Well, what had happened was, and it's the first time for them to speak, and they may launch into the whole story. It's the board's job to be like, all right, you know what? We're just at opening statements right now. You will have an opportunity to present your case. So if you'll please reserve your statements so later on, we'll get to that at the appropriate time. But the department gets to put their case on first. This was just for short opening statements. So that's something that I would be cognizant of. It is common that first time you give them a platform, you might get everything all at once. So, and then here is a really broad, it is one sentence that encapsulates basically the whole hearing. So complaint counsel may now proceed. Then this is, Kat can start calling witnesses. She'll start providing evidence. This is where all of the meat of the hearing comes into play. But there's no real, other than, Kat calls a witness, that she gives any documents associated with it that need to be authenticated. She questions them, then it's cross-examination. Then after Kat's done, she'll say, department rests, and then go over to the respondent. They can call any witnesses they have, present their evidence. But how that cadence goes varies so much from hearing to hearing, depends so much on the number of witnesses, the amount of evidence, all of that, that there's a huge gap here, because it's going to really just, again, vary depending on the substance of the hearing. So we now skip all the way through all of the meat of that down to closing arguments, because that's the next time that really the hearing officer is going to switch gears to that next phase. And so actually, just before closing arguments, I also want to say, in addition to being in control of when these next steps happen, and if people are kind of going off on tangents, one of the things you can do is you can ask questions at any time. So there's no prescribed period you have to wait to be able to ask a question. You are, you're in control of the information that you really want to intake, that you need in order to make a decision. So floor is always yours with the board members. So we get to closing arguments. This is your opportunity to summarize everything. This is the time when Kat can speak in a way that's not just asking questions. So the whole time that she's been interacting with witnesses, she's just asking them questions and you're hearing their testimony. Now she's going to try to tie together everything you've learned during the hearing itself. Kat goes, or the department goes first, then the respondent will follow. Now, here is the crux of it. Here's the most important part, is that then what do you guys do? So I mentioned before that you already have the complaint. So the complaint is really a key roadmap, because what it has in there is not just who the case is against, what the alleged violations are, which are really important, but it'll have findings of fact in there, or it'll have, allegations of violation in there with a little bit more substance, explaining then what we want to have considered as findings of fact, what we think led up to these violations of law. It will also have in there a prayer for relief. So what does the department want as the remedy to this? Does the department want the person to be fined $5,000? Does he want the license to be revoked? Does he want, what do we think would make the situation whole? So what you want to do, or what we ask the board to do, is to review each allegation that was outlined in the complaint and decide whether or not you agree with it. Did the department prove their case? Did the department actually prove that that violation of law occurred? So, this is an easy one, but were they licensed during that time? And did they enter into a contract? Well, if we allege that they were licensed during that time, then assuming Kat's going to show you either a screenshot or a picture of their license, something from our formal licensing system that demonstrates they were. If we say they entered into a contract, then we want to actually be able to see that contract. So those are the type of things that you'd be looking for to be able to determine whether or not the case was proven. And that is going to be for the findings of fact section. So the decision is going to have findings of fact. We'll have, I don't know if yours has we'll get into the template, but usually you'll have the findings of fact, then conclusions of law, and order. So the facts section is just like what goes into it. That, you say again, they proved that the respondent was licensed. The conclusions of law we'll say in this case, the department wasn't, or the respondent wasn't licensed during the time they were supposed to be. And because of the fact that they weren't licensed, we go down and in the conclusions of law section, say because of that, and they did the work at that time, they violated this statute. The third part of it is the orders. Because they weren't licensed during this time and they violated this law, they now have to pay $4,000, whatever that remedy is that you think is appropriate. And so I said in the complaint that Kat is going to outline what she believes is appropriate, whether it's restitution for consumer, civil penalty, revocation of license, whatever that penalty should be. You don't have to agree with her. So let's say that during the hearing, she's asking for revocation of a license. And you're like, it was bad. I don't know if it was that bad. Maybe you say the person should have their license suspended for a year. Maybe you say, you know what, I don't even know that a suspension's like an appropriate remedy. Let's fine them $10,000. So we are going to ask you for what we want, but you don't have to agree with us. We always appreciate when you do, but this is we're realistic. So, and also, I mean, all kidding aside, what happens is that evidence comes out at these hearings. That's the whole point of this, is that, you know, we may find out something we didn't know before. As professionals in the field, you may see things different than us as government regulators do that don't know this industry the way they do. So, you know, that's just, we understand that that's a reality of how things work. So actually, I'm going to pause here. One of the things that we will be doing is that since this is your first hearing in a while, Kat will be drafting a draft. She will be providing a draft decision for the board to review and then determine whether or not they agree with the decision as drafted. Now, what she will do is she will not provide the decision at the time of the hearing because we don't know what respondents' evidence is going to be necessarily. They could introduce new exhibits, they could introduce new witnesses. So that needs to be considered, that needs to be, you know, finalized afterward. What we do want to do though is provide you with that decision within a week of the hearing, because we want you to meet again right after the hearing, like about a week, 10 days after the hearing, to make sure that you guys go on the record and deliberate and decide how you're going to rule on the case and decide whether or not you want any changes to the draft decision. At that time, you know, someone should be going through that actual decision, like while you're all together and saying, well, actually, no, I don't agree with this finding of fact. Oh, let's modify the civil penalty from 10,000 to 5,000 or 5,000 to 15,000. Maybe it's significantly worse than we originally thought. It comes out at the hearing. But in this case, you know, sometimes we have the boards actually draft their own decisions. Since it's been a while, we are going to provide one to you that's generally filled out, and then you can decide whether or not you agree with it when you come back to deliberate. A lot of times, yeah, I'd say a lot. I say the majority of the time that we have cases, we will have boards deliberate like at the time the hearing concludes. So after someone is given, after both parties have given their closing statements, we will have the board say, all right, let's go through these findings of fact, and they can actually do these things on the record immediately. Now, oftentimes, those are easier cases where, you know, someone is unlicensed and we have evidence that they entered into contracts. The person then never performed any work for the contracts they entered into. The board's going to order restitution for consumers in the amount of the original or the amount of the deposits that were paid. Like, you know, a lot of times it's more clean cut. There are certainly reasons that after a case is closed, or after the conclusion of the closing statements, you may need more information. So let me go down here. Oh, actually, so I did skip this part. And I don't think this is relevant in your case, but if there's more than one respondent in a case, so let's say this happens a lot of times in like maybe the home improvement world, something like that, where you'll have, you know, Jerry Smith, who the case is against, but it's also against Jerry's roofing company. And if you have two respondents and you say, okay, you have to pay $10,000, who has to pay $10,000? So just specifying how that works if there are two, but I don't believe that's the case here. But so one of the things that I think is important to know is, you know, you get to the end, the closing statements have concluded, and it's not clear cut. There are issues here where you're not really sure if the respondent really did violate the law in certain aspects, or you're unclear, you think, you know, maybe you're like, this is so egregious. I want to fine them $100,000. Do we have the authority to fine them $100,000? Do we, you know, there are just situations where you might want additional clarity. So each board at DCP is represented by the Attorney General. The Board of Accountancy is no exception. So we have, especially with the transition from Frank with his retirement, we made sure that we reached out to the Attorney General's office again and just connected on kind of what the needs might be of the board, that we are having hearings coming up, and an attorney named Alma has been assigned to you. After this hearing, or sorry, after this training, I'm going to be sending out these materials that we're going over today. I'll also be sending out contact information for Alma, so that if there are these questions, then one of the things you can say is that, oh, I feel like we need additional guidance from the Office of the Attorney General, and we'll be reaching out to the AG. And this is one of those instances. So generally, all of your meetings have to be on the record. So they're all public meetings, no exception for hearings. So when we do schedule about a week, 10 days out, a period for deliberation on the decision, that will also be a public meeting on the record. If there is a point of law that you want to discuss with your attorney, what would happen is that we would publish a notice of a public meeting, but immediately you could go into executive session. And in that executive session, you could have a very frank conversation about the points of law that you need clarification on, and then be able to, again, just discuss that without being broadcast on Zoom and Teams or any of the platforms. So the way that you can do this, so I think I didn't. I guess I did it further down, but I guess, so this is where there are kind of three options for how you're going to be closing out the hearing. And so I guess this best goes down here, and they're listed out under closing statement. So if you want to keep, so if someone said, I have additional evidence, I don't have it on me right now, I'll get it to you within the next 5 days. You can keep the record open when it's getting closed out. Or when you can keep the record open at the conclusion of the hearing that day. You will not be closing the record. The record has to be left open for a certain period of time for them to provide it. So let's say, you're going to accept the tax returns from person A from 2016, and they have to be provided in the next 5 calendar days. It doesn't, so I put in 5 calendar days here. It can be, again, whatever you deem appropriate. It could be 24 hours, it could be 60 days, it's your call. What we do say is they have to be emailed in to Terry Jo and to the department. And, actually I say this part, maybe Kat finds something during the hearing that she says, I really want to keep the record open so I can submit something afterwards. It goes both ways. The big thing is that there's always an opportunity to object to a document. So let's say that the respondent sends something in, they send in this letter from a town, and Kat has a copy of the letter from the town that she got directly from. And she's like, that's not what the letter says, or that's not the day it was dated. I have an issue with the authenticity of this document. She has 10 days to object in writing. And she has to tell you she has a problem. If Kat doesn't tell you during those 10 days, then it can be admitted into the record. Again, unless the board for some reason says, we don't think that this should be admitted into the record. And then, so in that event, there's no need to reconvene. There's no objection to it. Then the record is closed as after so it's after the end of the hearing plus 5 days in this instance. Again, you can modify that, 5 days, and then that 10 days afterwards. Once that time here is concluded, then the record is closed and you can deliberate, make your decision. If there is an objection, then the record has to be reopened and another hearing date will be set so that Kat can explain what the objection is, and then you can go from there, unless the other party just withdraws it as soon as CAT challenges it. But generally, you'll have another hearing date set. And then you just let people know that the board has 90 days after the record is closed, officially closed. You have 90 days to issue a decision. So that's where we want to really get the process moving quickly of CAT getting a draft decision, you deliberating on it, and then in that case, we hopefully would get out a decision within a month, but we have legally up to 90 days. And then we let people know that they can appeal, and that is going to be outlined in the decision itself or in the letter that accompanies the decision. So people will understand their rights then. And then you adjourn. So if it is more clean cut and you're like, you know what, we got this, let's wrap this up today, then what can happen is you go through and you state on the record your findings of fact, which you will have outlined earlier on. We'll have talked through all of those things, but say which facts you found compelling and proven by either the respondent or the department. You're going to actually spell out, okay, because of this, they violated these laws, and then specifically state what the penalty is going to be. And you can do that all same day at that hearing. If you don't have any other questions, or you think that it's pretty open, closed issue, then that's it. One of the things we do say, though, is that if you are going to impose a civil penalty, please give a due date, because otherwise it lingers out there forever.
Mm.
But we also recommend, boards don't have to do this, but I do request that if you put something in that says, if they don't pay by a set date, what happens? Because we as a department will send someone into collections. It is not an impactful thing to do. It's basically, we will send someone through 2 or 3 years of churning through a bureaucratic machine until finally they may get sent over to a department that could potentially garnish someone's tax returns if it's an individual and they receive a refund on any consistent basis. And then shortly thereafter, it'll basically be written off by the state. Our collections process is not a solid hammer. I'm just gonna throw it out there that way. What is more of a hammer is if this person is licensed and we say, you pay $5,000 or your credentials suspended until you actually pay that amount. Taking away someone's livelihood is a much stronger issue. So, yeah, so if possible, we like to have the when it's due and then if then statement followed up with that. And then it's the same thing that all of these will kind of close the same way. You have 90 days, we'll give you your appeal rights, thanks for coming, closed as of this time. Now, this is where I go back to the Attorney General's, or the Office of the Attorney General's information. So if you want to consult with the AG, then you just say so. Just say, we have outstanding legal issues and we are going to set up a time to speak with them. And then we will move forward with how we want to conclude this case. And that's fine. You don't have to necessarily state what the legal issues are. I think it'll probably be clear from the conversation that's been happening as part of the hearing, what points need additional clarification. But yeah, that's kind of, those are the options. And if here, I guess when we're going to have the deliberation actually happen at a different meeting, because we are going to be providing with a draft decision. It actually is is kind of a modification of reaching a decision on the record. I guess you guys are actually gonna have this fourth option that most people don't have. And the fourth option is going to be, if you're not reaching a decision that day, then you can say, the board will schedule an additional time for deliberation and review of a draft decision. So when I send you out an email as follow-up to this, I can provide you with some language that just, again, outlines that fourth option, because most, it's just not common that that's how these conclude, but I will send out language on that. So just making a note.
Why do we have that and others don't?
Because you haven't had a hearing in a very long time. And so it's something that what we hope is that we will provide with this template this time, and that going forward is a template that you might be able to modify after, seeing the flow, seeing how this all looks. Also, you have different attorney general representation than most of our other boards. The boards we have, oftentimes it's like how these different groups have been brought into the division over time. So Liquor Control Commission has a different AG than drug control, or the Board of Pharmacy, different from Board of Accountancy, different from the electricians, the accountants. It's kind of all over the place. We have been a refuge for a lot of separate agencies that then got merged under the consumer protection umbrella over time. So yeah, and so I think that is basically, let's see, yep, that is it for this. Just a couple oh sure.
I have a question. Okay, obviously most of our actions are recorded, but in terms of the deliberations part after the evidence, is that going to be recorded and a matter of public record?
Yeah, it's awkward.
because
I'm not gonna lie. Yeah, it's.
That's that usually the decision maker, like I'll take an analogy of a jury, those deliberations are private.
I hear you, I do. And I completely respect why that is, it can be awkward to have these conversations, especially when the respondent's in the room. So you are talking about a person as if they don't exist for the purpose of your deliberation, and they're not allowed to chime in. So when you're saying, yeah, you know what, I think really this was terribly egregious, like they're staying on mute, and Terry Jo will, if they try to chime in, Terry Jo will mute them, and they'll also, be incumbent on the board to say, we are no longer hearing testimony from anyone, in the event that they can't stay, in the event that they don't remain silent during that time, Terry Jo will, I don't know, she somehow moves them from a participant to something else, and so that they can't engage at all.
Has there ever been discussions with the Attorney General about the fact that the deliberations of the board at the conclusion of any evidentiary part would be confidential?
They're only confidential in the event that you are asking your attorney for specific legal advice about a specific legal issue.
Okay, that's
general.
That's not the question I asked. The question I asked was, has there ever been a discussion with the Attorney General about whether a board like ours can make our deliberations confidential and not recorded?
You cannot. That is based on the Freedom of Information Commission. The Freedom of Information Commission has numerous rulings that you cannot have these deliberations in general based on how you're going to be making a decision, not an interpretation of law, but a decision on a finding of fact of whether evidence was compelling, whether you think 5,000 or 10,000 is a better fee. These are not deliberations that may be in a closed session. They don't qualify for executive session, and they can't be in a meeting that's not recorded.
And that's been decisions by the Freedom of Information Commission have established that.
Correct. And this applies for all boards.
Well, do the board members have immunity from individual lawsuits if there's an allegation of bias when the decision was made?
Well, you have state immunity. You are functionally a state agency. And so, yes, you are represented by the Office of the Attorney General. If there's some issue that you feel like needs to be brought up, if this is a familial relation, if you have ownership in the company, that's going to be addressed, there's something you should bring up now. But just because you worked with someone 10 years ago doesn't preclude you from hearing the case. Just because you both were, bidding on a contract to service the town of Manchester doesn't mean that someone should be precluded from the case. So it's going to be one of these things where, your bias, I don't know necessarily how that would come into play, but everyone brings their own bias in when they're serving as a hearing officer. Everyone brings their own personal experiences. But what we ask is that you look objectively at the evidence and make a decision on what the evidence proves to you. And so, yeah, that's really.
When I use the term bias, I'm hypothesizing a situation where our deliberations are open to the public and recorded, and someone alleges that their civil rights are being violated because of a bias based on, whatever, religion, sexual preference, whatever.
Then they can appeal to the Superior Court. They can appeal the decision of the case to the Superior Court.
Right, but I'm thinking about the individual liability of the board members.
We have not had an instance since I've been here, nor one that I know of, and you can consult with your AAG if you feel that you need to have additional conversation about this, where there's been an individual board member that's been called out for related to any adverse decision. What gets appealed is the decision, because what they want to change is the outcome.
Right.
They may say that they feel like they got an unfair shake, but you're also one of 7 members. So your voice only counts so much. That's one of those things where the board's much more insulated than our hearing officers, because Kat also serves as a hearing officer in additional capacities in the board. And I will tell you that when her decisions get challenged, her decisions, they're not appealing, they're not suing Kat. They're appealing a decision of the Superior Court, and we get served under the commissioner. So it's the Commissioner of Consumer Protection and the Department of Consumer Protection that will receive the case in the suit. It will not, so it won't be you necessarily individually. Can't think of an instance where it has been an individual commission member. It is the board as a whole, because they want a different outcome.
Thank you.
So one other just side note is that I would recommend that you will get to the hearing 5 minutes early max. The big thing is to not speak or do anything until the time of the hearing, generally also when the respondent's there. The board chair will then call the meeting to order, which is when the hearing will actually start being recorded. So that's where in the script you'll also see, and the meeting was convened at X time, and that'll coincide with when the recording starts. And I think that's the general scope of what we have. I don't know if I just talked fast, or maybe I've done too many of these. This is usually it takes the full 90 minutes, or if there haven't been as many questions. But I don't want to keep you guys for longer than we need to. But so just so I know which which board member will be serving as the hearing, as the presiding officer over the hearing? Okay.
That would
That's what I
normally
figured.
be me.
Okay.
That, the document that you were scrolling through, I presume we'll get a copy of that?
Yes, so I'm going to send you that. I'm going to send you, just so you guys can see it, the hearing instructions that we send out to respondents and witnesses. So that just tells them, that they have to let us know, like, they'll give us their exhibits 1 week in advance, the witness list 1 week in advance, just so you guys see what they're getting. And then I will also send you the contact information for Alma over at the Office of the Attorney General, and I will send you just a little snippet of the decision language. So in the event that you are going to, that you're not going to make the decision on the record that day, you're going to deliberate that further at that future meeting and review the draft decision, then I'll give you that language you can plug in there, so that it, so that will be done.
I'll just add, although I can't really imagine necessarily a situation where anybody would attack us, but I understand Carla's point, because if you're really not considered the equivalent of a state employee, that the AG would defend you is good, but it's usually the process. The process is the punishment. And so, board members do want to make sure that they're, exempt from that process if they've met their duties appropriately.
I mean, here's the thing, is that realistically, any of us can get sued at any time.
So I understand that.
I mean, in terms of serving in this role. So can I promise you that no one's going to sue you as part of this? No. But
No.
You for denying any application or
No, just I think she wanted confirmation of what exactly the status was, which was the question.
Yes.
So typically, again, the appeals come from the board decision, and it's really it's what's rendered in writing is what's going to be the basis of that appeal. So you can generally, I mean, you can deliberate pretty freely. You can say, well, but did you find this compelling? What did you think about this? And have those real conversations. You do, and there are going to be times where you're going to say, I didn't find that witness credible. You're probably going to want to say, if you're going to be writing off the testimony of a particular witness, then I would recommend saying, I didn't find them credible because of X, Y, and Z. It's so that you don't get accused later of saying, well, I didn't find them credible because they were a woman, or I didn't find them credible because they were Asian. Like, it is saying specifically, their story changed from when they said they were doing this project to that project, or whatever the case may be. But yeah, that's where the outline of the decision of the findings of fact, then the conclusions of law, and having that all follow into what the appropriate penalty is, really gives you that insulation of saying, I'm spelling out exactly why we're making these decisions. This is something that we've been really harping on, not as much, I mean, you guys haven't had as many hearings, but with some other boards, what we found in the past is that they were functionally like voting at the end of the hearing. So they'd hear all this evidence, and then you'd have 6 out of 8 people be like, I think they're guilty. I think that they violated whatever law it was. We didn't have a whole lot of substance there. And those are real easy to work because, why? I don't feel like there was, I don't think there was a functional basis for this. And then the court may say, well, yeah, there's no real record of how you reached that conclusion. And so it was putting us in a bad spot. And also it wasn't helping us set precedent. So with doing something like this, we can say, okay, well, you were working without a license for 10 years and you got a penalty of $10,000. So, all right, next time someone's been working without a license for 5 years, I don't know that it works this way, but you maybe say like, all right, well, they get $5,000 but you're establishing a baseline for when some of these penalties come up in the future. like what the board thinks is appropriate, an appropriate way of, you know, meting out penalties. So, but I think, I mean, in general, it might be a good thing to have, I don't know when your next regularly scheduled board meeting is, but maybe one thing that Kat and I can do is see if Alma can come to one of your board meetings, just so that you can put a face with the name. So you can see your AAG who's assigned to you in the case that, you know, these
Good idea.
questions come up. So, and no one likes to meet their attorney in a moment of crisis. So if you can do it while you're all smiling, it's always better. So. And so I am here if you guys have any questions, especially if you have any questions, you know, that are more specific to the hearing and any of the subject matter. I am intentionally, you know, staying out of it so that I can, you know, objectively review the decision at the end, but also so that, you know, this is Kat's case. She'll be, you know, presenting it to you, and yet you obviously can't talk to her about the specifics of it. So if you have any questions about the complaint, how it should be interpreted, stuff like that, you can let me know.
Julianne, if the respondent doesn't appear, do we still have to go through the whole process? Kat presents her case.
Yes, Kat
Yes,
still has to
okay.
present all the case to her, all the evidence, and go through all of that. Definitely speeds things up though. So, you know, I think with most of our cases, there's, and I would say at this point, with kind of how we've been doing that, with a vast majority of cases, the respondent appears.
Okay.
Because, you know, typically where people are willing to settle with us, we're negotiating things out. And it's people with lower level credentials that oftentimes won't appear. When I say lower level credentials, like a home improvement contractor has to pay $220 a year, and they're a home improvement contractor. That's it. There's no other. I can become one in the next 15 minutes.
Wow.
So when we threaten that credential, they're like, meh. Sometimes they're just like, all right, whatever, take it. I'm gonna register my wife and I'll go work under her. And so those are the cases that we generally will see people not respond to. But if you're working in a field where it takes a decade to be able to train up and then take all the tests, you're much more likely to respond in the case of enforcement action.
Could I also ask, like, all the exhibits, are they redacted, like with personal information and so forth?
Yes. So in the event that it's, you know, I'm not sure the specifics of this case, but let's say Kat, for some reason, is showing that it was a workmanship issue, that it, you know, there were egregious violations of how the tax returns were prepared. She's going to redact social security numbers, she'll redact date of birth, stuff like that. You know, there will still be, you know, she'll redact what is confidential and personally identifiable information in these, but you know, the telephone number, the email addresses, stuff like that is still, that's not personally identifiable information that is subject to redaction. But yes, we will not be emailing you documents that aren't. Because also what we email you has to be the same thing that Terry Jo puts up on the screen.
Okay.
So Kat, is there anything I'm missing that you're hoping that we cover?
No, you do. You covered everything. Thank you.
So yeah, like I said, I'm available. I'll be emailing you guys all shortly, so you'll have my contact information, and we can go from there. Well, I thank you all for your time today. It was a pleasure seeing you.
Thank you.
Thank you.
Thank you.
Right, thanks.
Julianne?
Bye. Yes.
Julian, I'm just going to stop the recording here.